Every legal system, every set of rules ever written, from the Code of Hammurabi to the United States Constitution to the World Trade Organization's founding charter, has a hidden page, a page nobody talks about, a page most people don't even know exists. It's the page that says, if everything breaks, if the system itself becomes the weapon, if the rules designed to protect you are being used to destroy you, then the rules no longer apply. Every legal system has this page because every legal system was written by people who understood that there would come a moment nobody wants, a moment everybody prays never arrives, when following the rules means dying by them. That page has a name in international trade law. It's called Article 21. And at 4:47 p.m. Eastern Standard Time this afternoon, Canadian Prime Minister Mark Carney opened to that page, read it aloud to the world, and activated a provision so powerful, so absolute, so rarely used that legal scholars believed it was essentially dormant. A relic. A theoretical safeguard from the 1940s that would never be invoked in the modern era because the consequences were too severe, the implications too vast, and the precedent too dangerous. Canada just invoked it against the United States of America, and the consequences are not theoretical anymore. Carney formally notified the World Trade Organization that Canada is activating Article 21 of the General Agreement on Tariffs and Trade, the Security Exception Clause, the nuclear option of international trade law, the provision that allows any WTO member to suspend all trade obligations to another member if that member's actions pose a threat to the invoking nation's essential security interests. All obligations, not some, not specific ones, not the ones related to tariffs or market access or intellectual property. Key, all of them. Under Article 21, Canada is declaring that the United States of America poses a threat to Canadian national security, and that Canada is therefore suspending every WTO obligation, every trade rule, every international constraint that has governed the U.S.-Canada economic relationship, starting now. This means Canada is no longer bound by any international trade rules governing its economic relationship with America. Let me be specific about what that includes, because the scope of this is unlike anything that has happened in modern trade history. Canada can impose unlimited tariffs on U.S. goods. Not 25%, not 50%, unlimited. 100%, 500%, 1,000%. There is no ceiling. There is no binding. There is no rule that says you can't go that high, because the rules don't apply anymore. Canada can ban imports from the United States entirely. Every product, every category, a complete embargo, legal under Article 21. Canada can nationalize U.S. corporate assets in Canada, factories, real estate, equipment, infrastructure, taken by the Canadian government without compensation, legal under Article 21. Canada can refuse to honor U.S. intellectual property, patents, trademarks, copyrights, trade secrets. Canadian companies can manufacture products using American technology without paying a single cent in licensing fees. Legal under Article 21. Canada can subsidize Canadian industries without limit, pour government money into any sector to make Canadian companies unbeatable against American competitors. Legal under Article 21. Canada can do anything economically because the international legal framework that normally constrains such actions, the framework that took 77 years to build, the framework that governs $25 trillion in annual global trade, the framework that was supposed to prevent exactly this kind of economic warfare between democracies, that framework no longer applies to U.S.-Canada trade. Article 21 has been invoked only a handful of times in the 77-year history of GATT and the WTO. India, Pakistan, Russia, Ukraine, cases of literal warfare, cases of imminent military conflict, cases where bombs were falling and soldiers were dying. Canada just invoked it against the United States, its closest ally, its largest trading partner, its neighbor, a fellow democracy, a fellow NATO member, a country it has fought beside in every major conflict for over a century. This is Canada declaring that economic relations with the United States are now governed by the same legal framework that applies during wartime. Because from Canada's perspective, from the perspective of a country whose sovereignty has been threatened, whose trade agreements have been violated, whose economy has been attacked, and whose partner has refused to honor commitments made by its own Congress. This is wartime, economic wartime. And Article 21 is the wartime authority. Trump thought he could ignore congressional override legislation and continue making demands. Trump thought he could veto implementation and face no consequences. Trump thought the rules would protect him, that international trade law would constrain Canada's response while he violated that same law with impunity. Carney just activated a legal mechanism that gives Canada unlimited economic warfare authority. And there is nothing the United States can do to stop it. Not legally, not diplomatically, not through the WTO, not through the courts, not through any mechanism that exists in international law, because Article 21 is self-judging. Canada decides whether the threat exists. Canada decides what actions are necessary. Canada decides when the authority expires, not the WTO, not an arbitration panel, not the United States. Canada. The rules that were supposed to protect America from exactly this kind of economic aggression, they have a page, a hidden page, that says if you threaten another nation's security, those rules don't protect you anymore. America just found that page the hard way. In this breakdown, I'm going to walk you through exactly what Article 21 allows Canada to do and why this is the most powerful economic weapon in international trade law. I'm going to show you the immediate reaction from global trade institutions and why the WTO itself is supporting Canada's invocation rather than challenging it. I'm going to reveal what happened in Washington when officials realized that Canada can now legally do anything it wants economically without WTO constraints, and why the U.S. has no legal recourse. I'm going to explain why Article 21 has never been invoked against a major trading partner before, and why Canada's use of it sets a precedent that could permanently reshape global trade, with the United States on the outside looking in. And I'm going to give you 3 scenarios for what happens when the world's most powerful economic weapon is aimed at the world's largest economy, with nobody able to take it away. Subscribe to join the community, leave a comment so we can keep the conversation going, and share this video, because what happened at 4:47 this afternoon doesn't just change trade law, it changes the meaning of American economic power itself. Let me walk you through what Article 21 of GATT actually says, because understanding the precise text is critical to grasping just how powerful, how absolute this provision is, and why the people who wrote it never expected it to be used like this. Article 21, titled Security Exceptions, states, "Nothing in this agreement shall be construed to prevent any contracting party from taking any action which it considers necessary for the protection of its essential security interests." Read that again, slowly, because every word in that sentence was chosen with surgical precision by the lawyers who drafted GATT in 1947. Nothing in this agreement. Not most provisions, not the tariff sections. Nothing. The entire agreement, every article, every obligation, every rule, all of it, overridden, shall be construed to prevent, not may limit or should discourage, shall not prevent. It's absolute, it's mandatory, it's not a suggestion, it's a command to every tribunal, every panel, every adjudicator. You cannot stop this. Any action. Not proportional action, not reasonable action, not action approved by the WTO. Any action, without limit, without ceiling, without constraint. If a nation invokes Article 21, it can do literally anything, which it considers necessary, not which the WTO considers necessary, not which an independent panel considers necessary, which it, the invoking nation, considers necessary. The determination is self-judging. Canada decides, not Washington, not Geneva, not anyone else, for the protection of its essential security interests. The threshold, the trigger, essential security, not economic convenience, not trade advantage, essential security. And here's the critical legal reality. Who decides what constitutes a threat to essential security? The invoking nation. Self-judging. Canada says it's a security threat, then it's a security threat. The WTO doesn't get to second-guess that determination. No panel reviews it. No appeals process overturns it. The nation speaks and the rules step aside. Now let me read you Canada's formal notification, because the language is precise, comprehensive, and designed to be legally bulletproof. Canada hereby invokes Article 21 of the General Agreement on Tariffs and Trade. Canada has determined that the actions of the United States of America, including violations of bilateral trade agreements, threats to Canadian sovereignty and territorial integrity, economic coercion designed to force policy changes, suspension and threatened termination of defense cooperation agreements, and refusal to honor commitments made by the United States Congress constitute a threat to Canada's essential security interests. 5 specific grounds, each one documented, each one provable, each one already acknowledged by U.S. government's own internal memos that Carney released last week. Violations of bilateral trade agreements. The USMCA tariffs ruled illegal by the agreement's own dispute resolution panel. Threats to sovereignty and territorial integrity. The 51st state comments, the annexation rhetoric. Economic coercion. The tariffs, the trade threats. I will turn Canada into an economic wasteland. Suspension of defense cooperation. The NORAD threats. The intelligence sharing cuts. Refusal to honor congressional commitments, Trump vetoing the override legislation that Congress passed. Every ground is documented. Every ground has been reported. Every ground was confirmed by the United States government's own classified memos. Canada didn't just invoke Article 21. Canada built a legal fortress around the invocation that no tribunal could penetrate even if one tried. Under Article 21, Canada is suspending all obligations under GATT and under WTO agreements with respect to trade with the United States, effective immediately. Effective immediately, not in 6 months, not after a review period. Now, the rules that govern $2 trillion in annual U.S.-Canada trade cease to apply at 4:47 this afternoon. Canada reserves the right to take any actions it deems necessary to protect Canadian security interests without constraint from international trade rules. Any actions, without constraint, the most powerful economic weapon in international law, loaded, aimed, and fired. Let me walk you through the practical implications, because the legal authority is one thing. What Canada can actually do with that authority is another. And the list is staggering. Most favored nation principle, suspended. This is the foundational rule of the WTO system. It says you have to treat all WTO members equally. If you give one country a tariff rate, you give all countries that rate. It prevents discrimination. Canada can now discriminate against U.S. goods while offering preferential treatment to everyone else. Canadian tariffs on Japanese products, 2%. On EU products, 0%. On American products, 200% legal, because MFN doesn't apply under Article 21. National treatment principle, suspended. This rule says you have to treat foreign goods the same as domestic goods once they enter your market. No favoring your own products over imports. Canada can now explicitly favor Canadian products over American products in Canadian markets. Government procurement contracts, Canadians only. Shelf space regulations, Canadian products prioritized. Subsidies, Canadian companies get them, American companies don't. Legal. Tariff bindings, suspended. WTO members agree to maximum tariff rates, bindings, that they won't exceed. These bindings are the ceiling that keeps tariffs from becoming weapons of economic war. For the United States, there is no ceiling anymore. Canada can impose 100% tariffs, 500% tariffs. The concept of a binding, a limit, a maximum, no longer exists for American goods entering Canada. The rate is whatever Canada says it is. Today, tomorrow. Different rate next week if Canada chooses. No constraint, no appeal. Quantitative restrictions, suspended. WTO rules generally prohibit outright bans on imports. You can tariff goods, but you can't just ban them. Canada can now ban American imports entirely. Any product, any category, all of them. A complete, total, legally sanctioned embargo on American goods entering Canada. Not as a violation of international law, under international law. Article 21 makes it legal. Intellectual property protections, suspended. TRIPS, the Agreement on Trade-Related Aspects of Intellectual Property Rights, requires WTO members to respect each other's patents, trademarks, and copyrights. American pharmaceutical companies, tech companies, and manufacturers depend on these protections to prevent their innovations from being copied. Those protections no longer apply to Canada. Canadian companies can manufacture products using American technology without paying licensing fees, without negotiating agreements, without asking permission. American patents are unenforceable in Canada. American copyrights are unenforceable in Canada. American trade secrets have no legal protection in Canada. Think about what that means for American pharmaceutical companies whose drugs are manufactured using processes protected by U.S. patents. Canadian generic manufacturers can now replicate those drugs legally without paying royalties, without waiting for patent expiration. The drugs that cost Americans $300 per prescription could be manufactured in Canada for $15 and sold to the world. Subsidies restrictions suspended. WTO rules limit how much governments can subsidize domestic industries because subsidies create unfair competitive advantages. Canada can now pour unlimited government money into any industry. Automotive manufacturing, subsidized. Energy technology, subsidized. Agriculture, subsidized. Any sector where Canadian companies compete with American companies, subsidized without limit, without constraint, without any rules saying that's unfair. Investment protections suspended. WTO rules protect foreign investments from arbitrary seizure, nationalization without compensation. Canada can now nationalize U.S.-owned factories, U.S.-owned real estate, U.S.-owned infrastructure, U.S.-owned natural resource operations taken by the Canadian government without compensation, without legal recourse, without any international rules saying they can't. Every American company with assets in Canada just lost the legal framework protecting those assets. The only thing standing between those assets and Canadian government seizure is Canada's choice not to seize them, and that choice is Canada's alone. This is the totality of Article 21. It doesn't remove one rule. It removes all rules. Every protection, every constraint, every limit, every guarantee that the international trading system provides, all of it gone. For the United States in its relationship with Canada, starting now. Subscribe right now, because what I'm about to show you is the global reaction and why the entire world just lined up behind Canada's invocation of the most powerful economic weapon in international law. At 5:15 p.m., 28 minutes after Canada's notification, WTO Director General Ngozi Okonjo-Iweala issued a statement. And this statement is the one that sealed America's fate. Because if the WTO had challenged Canada's invocation, if the institution had said, this is an abuse of Article 21, we don't accept it, there might have been a path to containment. The WTO didn't challenge it. The WTO endorsed it. The WTO has received Canada's notification of Article 21 invocation regarding trade with the United States. Article 21 is a legitimate provision of GATT that recognizes nations have the sovereign right to protect their security. While Article 21 invocations are rare, Canada's notification meets the legal requirements. The WTO will not challenge Canada's determination that its security interests are threatened. Member states have the right to make that determination for themselves. The WTO will not challenge. The institution created to govern international trade just told the United States, you are on your own. We will not intervene. We will not overrule. We will not protect you. Canada has the right to do this, and we recognize that right. The referee just left the field, and the side that was already losing just lost the only thing that was preventing the other side from scoring at will. 5:30 p.m. The European Union. The EU supports Canada's invocation of Article 21. The United States' actions toward Canada, including violation of USMCA, threats to sovereignty, and refusal to honor congressional legislation, constitute behavior that justifies security exception claims. The EU will not challenge Canada's Article 21 invocation and will continue to support Canada's defense of its sovereignty. The EU doesn't just accept Canada's invocation. The EU supports it. The EU is saying America's behavior justifies this. Canada is right to do this. We agree with the grounds. We endorse the action. When the world's largest economic bloc tells you that your own behavior justified the invocation of wartime trade authority against you, and that is not a disagreement, that is a verdict. 5:45 p.m. Japan, supporting Canada's legal position. 6:00 p.m. the Democratic Trade Alliance Secretariat. All 62 member nations have agreed to support Canada's Article 21 invocation. And critically, alliance members will coordinate to ensure Canada has access to any goods or services that Canada might previously have imported from the United States. That last part is the operational backup. If Canada bans U.S. imports, it needs replacement sources. The DTA just guaranteed those sources. 62 countries standing ready to fill any gap that cutting off American trade creates. Canada isn't just invoking Article 21. Canada has a 62-nation supply chain backup, ensuring that the economic weapon can be fired without Canada suffering the recoil. 6:15 p.m. China. Carefully worded. Beijing is always carefully worded, but unmistakable in its meaning. Article 21 exists precisely for situations where a nation faces security threats from a trading partner. China respects Canada's sovereign right to invoke available legal mechanisms. China has been watching the U.S.-Canada crisis from the beginning, not as a concerned bystander, as a student, taking notes, learning, watching a Western democracy successfully deploy economic warfare mechanisms against the United States, and watching those mechanisms receive global endorsement. Every tool Canada uses, every precedent Canada sets, every legal mechanism Canada activates, China files away for future reference. Because if a Canadian democracy can invoke Article 21 against the United States and receive WTO endorsement, European backing, and global support, what happens when China invokes Article 21? That question, sitting unasked in every strategy paper in Washington, is the long-term consequence that dwarfs everything else. Canada may be the first country to use this weapon against America. China is taking notes on how to be the second. By 7 p.m., every major trading nation except the United States had issued statements either explicitly supporting Canada's Article 21 invocation or declining to challenge it. Every single one. The global trade community, the community that the United States helped build, that the United States helped govern, that the United States helped enforce for 77 years, just gave Canada a green light to conduct unlimited economic warfare against the United States under color of international law. The United States didn't just lose a trade dispute. The United States just lost the protection of the international trading system it created. Here's what happened in Washington, and I want you to listen to the progression, because it is the sound of a government realizing in real time that the legal architecture it built to protect itself has been turned into the legal architecture of its own destruction. 5 p.m., the U.S. Trade Representative was informed of Canada's notification to the WTO. An emergency meeting was convened immediately. Legal advisors were pulled in. The question was urgent. Can we challenge this? Legal counsel reviewed Article 21. They reviewed the history of invocations. They reviewed the WTO's own jurisprudence on security exceptions. And they reached a conclusion that sources describe as devastating. Article 21 invocations are self-judging. The invoking nation determines whether the threat exists. The WTO dispute resolution system does not have authority to overrule a member's security determination. The appellate body has historically declined to review Article 21 claims. There is no mechanism in international trade law for the United States to challenge, override, overturn, or reverse Canada's invocation. The U.S. has no legal recourse, none. The rules-based system that America spent 77 years building, the system designed to prevent exactly this kind of unconstrained economic warfare between major trading partners, cannot help America. Because America's own behavior triggered the one provision that puts a nation outside the system's protection. 5:30 p.m., National Security Council emergency meeting. Officials discussed the implications across every dimension, and every dimension was catastrophic. Treasury warned, if Canada imposes extreme tariffs or bans U.S. imports, American exporters lose access to their second largest market, hundreds of billions in annual exports at risk. thousands of companies at risk, millions of jobs at risk, and there's no WTO mechanism to challenge it. Commerce warned if Canada ignores U.S. intellectual property, American companies face billions in losses from unauthorized use of U.S. technology, pharmaceutical patents, tech patents, manufacturing processes, all legally unprotected in Canada, and Canadian-made alternatives using American technology at a fraction of the price, competing with American products in global markets. State delivered the warning that should keep every American strategist awake for the next decade. Canada's Article 21 invocation sets a precedent. Other countries can follow. If the EU invokes Article 21 against the United States, citing the same grounds, trade agreement violations, coercive behavior, sovereignty threats, the entire rules-based trading system collapses for America. Not because the system fails, because the system excludes America, one country at a time. 6:01 p.m. Trump was briefed. According to sources, Trump was told that Canada just invoked a provision that allows Canada to ignore all trade rules when dealing with the United States. Trump reportedly asked, "What can we do to stop it?" The answer, delivered by every advisor in the room, was the same answer that has been delivered at every briefing, in every crisis meeting, at every turning point of this catastrophe. Nothing. There is nothing the U.S. can do legally. Article 21 is a recognized provision of international trade law. Canada's invocation is valid. The WTO has endorsed it. Every major trading nation supports it. There is no challenge. There is no appeal. There is no override. Trump reportedly said, "Then we'll invoke it too. We'll cut off all trade with Canada." And his advisors, exhausted, depleted, running out of ways to explain the same reality to a man who refuses to absorb it, reportedly told him the truth one more time. The U.S. needs Canadian imports, particularly energy, far more than Canada needs U.S. markets. Canada has redirected trade to the Democratic Trade Alliance. Canada has 62 alternative partners. The U.S. has no alternative source for what Canada provides. A U.S. invocation of Article 21 against Canada would be like a man standing in a house fire invoking his right to stop buying fire extinguishers. You're not punishing the other side. You're accelerating your own destruction. 6:30 p.m. White House statement. Canada's invocation of Article 21 is an abuse of a provision designed for actual security threats like war or terrorism. Canada is not facing a security threat from the United States. This is a cynical legal maneuver designed to justify economic aggression. The United States will challenge this invocation at the WTO and will take all necessary measures to protect American interests. We'll challenge at the WTO. Legal experts across the world immediately pointed out what the White House either doesn't understand or is hoping the public doesn't understand. Article 21 invocations are not subject to WTO dispute resolution. There is no avenue for challenge. The White House is threatening to use a legal mechanism that does not exist. It's like threatening to appeal to the Supreme Court in a country that doesn't have one. The institution the White House is invoking for protection cannot provide that protection, because the very provision Canada activated is designed to operate outside that institution's authority. The White House is threatening to fight with a weapon that doesn't fire against an opponent holding a weapon that fires without limit.